Welcome to episode 91 on the Law Report. Very recently, I came across a leaflet that is displayed in the Supreme Court and available to members of the public, setting out the process if someone or when someone is summoned to appear in court. I think that it is a very necessary document. It is available to the public, so anyone visiting the Supreme Court can avail themselves of one of these leaflets. And I want to use this episode to go through this document in order to enlighten the public and the process when he or she is summoned to appear in court, whether as a witness or a defendant in a civil matter or criminal proceedings. But before I get into the document, my usual disclaimer: this is not legal advice, should not be construed as such. For legal advice, please contact an attorney of your choice. First, let me explain what is a summons. A summons is a legal document issued out of the court and served on a person, compelling them to attend court, whether as a witness or a defendant in a civil matter or criminal proceedings. This is the leaflet I am referring to that you could pick up at the Supreme Court offices on Leeward Highway. So the document begins: when you can be summoned as a witness in court proceedings. And it says you can be summoned as a witness to testify in a criminal case, a civil matter, or divorce proceedings before the Supreme Court by a party to the case, or you may be invited to assist the court as an expert witness. How will you know if you are required to attend court? You will be informed of your need to testify in court proceedings when you are served a witness summons. A party to a case or a police officer may personally serve you the witness summons. A witness summons is a document issued by the court addressed to you. It will contain the court stamp. The witness summons will list the following information. 1. The court case in which you are required to testify. 2. The judge before whom you will appear. 3. The court location, the mode of hearing, the date and time of hearing, and any documents that you are required to produce at the hearing. So what is very important is that the summons must have the court seal to show that it was issued officially out of the court. What do you do when you receive a witness summons? You take note of the date, the time, the location, and the mode of hearing. When you receive a witness summons, you should take note of the date, time, and location or mode of hearing. Some hearings are conducted in person, virtually, or hybrid, that is, partially in person and partially virtual. As such, upon being served a witness summons, it is crucial that you ascertain the location and the mode of hearing being utilized. Should you have any difficulty appearing at the specified court location or via the specified mode of hearing, you should inform the person who issued the summons as soon as possible so that alternative arrangements can be made with the court to facilitate your attendance on the scheduled date. Failure to appear on the date and time stated in the witness summons may in certain circumstances attract punishment. The document continues. The document that is available to the public at the court offices at the Leeward Highway. The document says, therefore, should you be unable to attend court on the specified date or time due to a valid reason, you should immediately inform the party that served you the summons. A. Take note of any documents you are required to produce. As a witness to a matter, you will be called upon to give evidence and any information in your possession. Such information will also include documents. Therefore, the witness summons may list specific documents that you are required to produce. In such an instance, you will be required to have those documents in your possession on the date of hearing. B. You should indicate if you require the use of an interpreter. So if English is not your first language. Should you require the use of an interpreter, you should immediately inform the person who served you with the summons so that the necessary arrangements can be made to have an interpreter who speaks your language attend court. See what to expect on the scheduled date of hearing. If you are summoned to attend an in-person hearing, you should ensure that you arrive at the court location at least 15 minutes before the time that the hearing is scheduled to start. You should inform the security officer that you have been summoned as a witness and indicate the particular case in which you are summoned. The security officer will direct you to the waiting area outside the courtroom. You are to only enter the courtroom when your name is called. You should not discuss the matter with anyone while you are waiting. When your name is called, you will enter the courtroom. and will be escorted to the witness stand. If you are attending a hearing virtually, you ought to join the link at least 15 minutes before the scheduled time of the virtual hearing. So if you are attending virtually instead of attending in person physically at the location of the hearing, a link will be sent to your email address where you can click on this link and access the court proceedings. You will be let into the virtual courtroom when the court is ready to hear your testimony. You are to ensure that your camera is turned on and your microphone is operational, because the court would need to hear what you have to say, because you're going to give evidence. Please remember that these are court proceedings, so you'll be required to dress properly, even if you're appearing virtually. If you are appearing virtually, you should also ensure that you are in a quiet location. When it's time for you to give your evidence, an oath will be administered to you. You may swear in the Bible, or you may affirm to tell the truth. You will be asked questions by the parties in the matter. You are to answer each question truthfully and to the best of your knowledge or recollection. Your evidence will be recorded. Therefore, you are to speak clearly and slowly. If you do not understand any question, you can ask for it to be repeated. And very importantly, according to the document that is available at the court offices on Leeward Highway, you are to refer to the judge as my lord, my lady, if the judge is a female, or sir or madam. If your case is adjourned and you are required to return on another day to continue to give evidence, you will be given a direction by the judge that you are not to discuss the matter with anyone. You are expected to strictly adhere to this direction. In the event that you're a vulnerable witness, and according to this document, and according to the law, I must add, a court can classify a person as a vulnerable witness based on A, age, B, vulnerability by reason of mental disorder, a significant impairment of intelligence and social functioning, a physical disability, or a physical disorder. C, fear, anxiety, or distress on the part of the witness testifying in the proceedings. Once the court is of the view that a person is a vulnerable witness, they are entitled to the protection of the court. Some of the special measures that can be adopted by the court to protect vulnerable witnesses in order to ensure a level of comfort to enable them to give the evidence truthfully and to the best of their knowledge or recollection may include a screen being placed between the witness and the accused person in the case of a criminal matter, to give the witness an acceptable level of comfort. The ability of a witness to give evidence by means of a live link. So that is the second measure that can be adopted by the court, to have the witness give evidence via a live link instead of attending personally at the court. And C, the exclusion of members of the public when the witness is giving his or her evidence. So this information was brought to you directly from this document that is available to the public at the Courthouse, Supreme Court Building on Leeward Highway. They are not my words. They are the words of the Supreme Court. This is to familiarize persons who may be summoned to attend court what to expect and their attendance. I hope that this episode has been helpful, that you understand that it is not legal advice, it is public information, and if it has been of any benefit to you, please share it, please comment. But most of all, I thank you for taking the time out from your busy schedule to listen or to watch this episode. Cheers. Thank you, and I will see you very shortly in my next episode.